Justice Barrett delivered the opinion of the court. The United States has filed 3 emergency applications challenging the scope of a federal court's authority to enjoin government officials from enforcing an executive order. Traditionally, courts issued injunctions prohibiting executive officials from enforcing a challenged law or policy only against the plaintiffs in the lawsuit. The injunctions before us today reflect a more recent development: district courts asserting the power to prohibit enforcement of a law or policy against anyone. These injunctions, known as universal injunctions, likely exceed the equitable authority that Congress has granted to federal courts. We therefore grant the government's applications to partially stay the injunctions entered below. Section 1. The applications before us concern 3 overlapping universal preliminary injunctions entered by 3 different district courts. The plaintiffs, individuals, organizations, and states, sought to enjoin the implementation and enforcement of President Trump's Executive Order number 14160.2. The executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is thus not recognized as an American citizen. Specifically, it sets forth the policy of the United States to no longer issue or accept documentation of citizenship in 2 scenarios. 1, when a person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. Or 2, when a person's mother's presence in the United States was lawful but temporary, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. The executive order also provides for a 30-day ramp-up period. During that time, the orders direct executive agencies to develop and issue public guidance regarding the order's implementation. The plaintiffs filed suit alleging that the executive order violates the 14th Amendment's Citizenship Clause, Section 1, as well as Section 201 of the Nationality Act of 1940, codified at 8 U.S.C. Section 1401. In each case, the district court concluded that the executive order is likely unlawful and entered a universal preliminary injunction barring various executive officials from applying the policy to anyone in the country. And in each case, the Court of Appeals denied the government's request to stay the sweeping relief. The government has now filed 3 nearly identical applications seeking to partially stay the universal preliminary injunctions and limit them to the parties. The applications do not raise, and thus we do not address, the question whether the executive order violates the Citizenship Clause or Nationality Act. The issue before us is one of remedy, whether under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. Section 2. The question whether Congress has granted federal courts the authority to universally enjoin the enforcement of an executive or legislative policy plainly warrants our review, as members of this court have repeatedly emphasized. On multiple occasions and across administrations, the Solicitor General has asked us to consider the propriety of this expansive remedy. It is easy to see why. By the end of the Biden administration, we had reached, quote, a state of affairs where almost every major presidential act was immediately frozen by a federal district court, unquote. The trend has continued. During the first 100 days of the second Trump administration, district courts issued approximately 25 universal injunctions. As the number of universal injunctions has increased, so too has the importance of the issue. Section 3, Part A. The government is likely to succeed on the merits of its argument regarding the scope of relief. A universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits in equity, and still today, this statute is what authorizes the federal courts to issue equitable remedies. Though flexible, this equitable authority is not freewheeling. We have held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. We must therefore ask whether universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery of England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act. The answer is no. Neither the universal injunction nor any analogous form of relief was available in the High Court of Chancery in England at the time of the founding. Equity offered a mechanism for the Crown, quote, to secure injustice where it would not be secured by the ordinary and existing processes of law, unquote. This judicial prerogative of the king thus extended to those causes which the ordinary judges were incapable of determining. Eventually, the Crown instituted the practice of delegating the cases that came before the judicial prerogative to the Chancellor for his sole decision. This became the common mode of dealing with such controversies. Of importance here, suits in equity were brought by and against individual parties. Indeed, the general rule in equity was that all persons materially interested in the suit were to be made parties to it. Injunctions were no exception. There were sometimes suits to restrain the actions of particular officers against particular plaintiffs. And in certain cases, the Attorney General could be a defendant. The Chancellor's remedies were also typically party-specific. As a general rule, an injunction could not bind one who was not a party to the cause. Suffice it to say, then, under long-standing equity practice in England, there was no remedy remotely like a national injunction. Nor did founding-era courts of equity in the United States chart a different course. If anything, the approach traditionally taken by federal courts cuts against the existence of such a sweeping remedy. Consider Scott v. Donald, where the plaintiff successfully challenged the constitutionality of a law on which state officials had relied to confiscate alcohol that the plaintiff kept for personal use. Although the plaintiff sought an injunction barring enforcement of the law against both himself and anyone else whose rights were infringed and threatened by it, this court permitted only a narrower decree between the parties named as plaintiffs and defendants in the bill. In the ensuing decades, we consistently rebuffed requests for relief that extended beyond the parties. As Justice Nelson put it while riding circuit, quote, there is scarcely a suit at law or in equity in which a general statute is interpreted that does not involve a question in which other parties are interested, unquote. But to allow all persons which subject to the statute to be treated as parties to a lawsuit would confound the established order of judicial proceedings. Our early refusals to grant relief to non-parties are consistent with the party-specific principles that permeate our understandings of equity. Neither declaratory nor injunctive relief, we have said, can directly interfere with enforcement of contested statutes or ordinances except with respect to the particular federal plaintiffs. In fact, universal injunctions were not a feature of federal court litigation until sometime in the 20th century. Yet such injunctions remained rare until the turn of the 21st century, when their use gradually accelerated. One study identified approximately 127 universal injunctions issued between 1963 and 2023. 96 of them, over three-quarters, were issued during the administrations of President George W. Bush, President Obama, President Trump, and President Biden. The bottom line? The universal injunction was conspicuously non-existent for most of our nation's history. Its absence from 18th and 19th century equity practice settles the question of judicial authority. That the absence continued into the 20th century renders any claim of historical pedigree still more implausible. Even during the deluge of constitutional litigation that occurred in the wake of Ex parte Young, throughout the Lochner era, and at the dawn of the New Deal, universal injunctions were nowhere to be found. Had federal courts believed themselves to possess the tool, surely they would not have let it lie idle. Faced with this timeline, the principal dissent accuses us of misunderstanding the nature of equity, as being frozen in amber at the time of the Judiciary Act. Not so. We said it before, and we say it again. Equity is flexible. At the same time, its flexibility is confined within the broad boundaries of traditional equitable relief. A modern device need not have an exact historical match, but under Grupo Mexicano, it must have a founding-era antecedent. and neither the universal injunction nor a sufficiently comparable predecessor was available from a court of equity at the time of our country's inception. Because the universal injunction lacks a historical pedigree, it falls outside the bounds of a federal court's equitable authority under the Judiciary Act. Part B. Respondents raise several counter-arguments, which the principal dissent echoes. First, they insist that the universal injunction has a sufficient historical analog, a decree resulting from a bill of peace. Second, they maintain that universal injunctions are consistent with the principle that a court of equity may fashion complete relief for the parties. Third, they argue that universal injunctions serve important policy objectives. 1. In an effort to satisfy Grupo Mexicano's historical test, respondents claim that universal injunctive relief does have a founding-era forebear. The decree obtained on a bill of peace, which was a form of group litigation permitted in English courts. This bill allowed the chancellor to consolidate multiple suits that involved a common claim the plaintiff could have against multiple defendants, or some kind of common claim that multiple plaintiffs could have against a single defendant. Universal injunctions are analogous to this traditional equitable device, respondent says, so federal courts have authority under the Judiciary Act to issue them. The analogy does not work. True, bills of peace allow courts of equity to adjudicate the rights of members of dispersed groups without formally joining them to a lawsuit through the usual procedures. Even so, their use was confined to limit circumstances. Unlike universal injunctions, which reach anyone affected by legislative or executive action, no matter how large the group or how tangential the effect, a bill of peace involved a group that was small and cohesive, and the suit did not resolve a question of legal interpretation for the entire realm. And unlike universal injunctions, which bind only the parties to the suit, decrees obtained on a bill of peace would bind all members of the group, whether they were present in the action or not. As Chief Judge Sutton aptly put it, quote, "The domesticated animal known as a bill of peace looks nothing like the dragon of nationwide injunctions," unquote. The Bill of Peace lives in modern form, but not as the universal injunction. It evolved into the modern class action, which is governed in federal court by Rule 23 of the Federal Rules of Civil Procedure. And while Rule 23 is in some ways more restrictive of representative suits than the original Bills of Peace, it would still be recognizable to an English chancellor. Rule 23 requires numerosity, such that joinder is impractical. Common questions of law or fact, typicality, and representative parties who adequately protect the interests of the class. The requirements for a Bill of Peace were virtually identical. None of these requirements is a prerequisite for a universal injunction. Rule 23's limits on class actions underscore a significant problem with universal injunctions. A properly conducted class action, we have said, can come about in federal courts in just one way, through the procedure set out in Rule 23. Yet by forging a shortcut to relief that benefits parties and non-parties alike, universal injunctions circumvent Rule 23's procedural protections and allow courts to create de facto class actions at will. Why bother with a Rule 23 class action when the quick fix of a universal injunction is on the table? The principal dissent's suggestion that these suits could have satisfied Rule 23's requirements simply proves that universal injunctions are a class action workaround. The taxpayer suit is a similarly inadequate historical analogy. In a successful taxpayer suit, a court would enjoin the collection of an unlawful tax against taxpayers joined as co-plaintiffs, or by one taxpayer suing on behalf of himself and all others similarly situated. To be sure, some state courts would occasionally enjoin the enforcement and collection of taxes against an entire community, even when a single taxpayer sued on his own account. But the practice of extending relief with respect to any taxpayer was not adopted by state courts until the mid-19th century, and even then, not all states were willing to provide such sweeping relief. This post-founding practice of some state courts thus sheds minimal light on federal courts' equitable authority under the Judiciary Act. What is more, in Frothingham, we refuse to allow a single taxpayer to challenge a Federal Appropriations Act. That counsels against placing much, if any, reliance on taxpayer suits as justification for the modern universal injunction. 2. Respondents contend that universal injunctions, or at least these universal injunctions, are consistent with the principle that a court of equity may fashion a remedy that awards complete relief. We agree that the complete relief principle has deep roots in equity, but to the extent respondents argue that it justifies the award of relief to non-parties, they are mistaken. Complete relief is not synonymous with universal relief. It is a narrower concept. The equitable tradition has long embraced the rule that courts generally may administer complete relief between the parties. While party-specific injunctions sometimes advantage non-parties, they do so only incidentally. Consider an archetypal case: a nuisance in which one neighbor sues another neighbor for blasting loud music at all hours of the night. To afford the plaintiff complete relief, the court has only one feasible option: order the defendant to turn her music down, or better yet, off. That order will necessarily benefit the defendant's surrounding neighbors too. There is no way to peel off just the portion of the nuisance that harmed the plaintiff. But while the court's injunction might have the practical effect of benefiting non-parties, that benefit is merely incidental. As a matter of law, the injunction's protection extends only to the suing plaintiff, as evidenced by the fact that only the plaintiff can enforce the judgment against the defendant responsible for the nuisance. If the nuisance persists, and another neighbor wants to shut it down, she must file her own suit. The individual and associational respondents are therefore wrong to characterize the universal injunction as simply an application of the complete relief principle. Under this principle, the question is not whether an injunction offers complete relief to everyone potentially affected by an allegedly unlawful act. It is whether an injunction will offer complete relief to the plaintiffs before the court. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship. Extending the injunction to cover all other similarly situated individuals would not render her relief any more complete. The complete relief inquiry is more complicated for the state respondents, because the relevant injunction does not purport to directly benefit non-parties. Instead, the District Court for the District of Massachusetts decided that a universal injunction was a necessary implementation to provide the states themselves with complete relief. The states maintained that the district court made the right call. As the states see it, their harms, financial injuries, and the administrative burdens flowing from citizen-dependent benefit programs cannot be remedied without a blanket ban on the enforcement of the executive order. Children often move across state lines or are born outside of their parents' state of residence. Given the cross-border flow, the states say a patchwork injunction would prove unworkable because it would require them to track and verify the immigration status of the parents of every child, along with the birth state of every child for whom they provide certain federally funded benefits. The government, unsurprisingly, sees matters differently. It retorts that even if the injunction is designed to benefit only states, it is more burdensome than necessary to redress their harms. After all, to say that a court can award complete relief is not to say that it should do so. Complete relief is not a guarantee. It is the maximum a court can provide. And in equity, the broader and deeper the remedy that plaintiff wants, the stronger the plaintiff's story needs to be. In short, the essence of equity jurisdiction has been the power of the chancellor to do equity and to mold each decree to the necessities of the particular case. Leaning on these principles, the government contends that the narrower relief is appropriate. For instance, the district court could forbid the government to apply the executive order within the respondent states, including to children born elsewhere but living in those states. Or the government says the district court could direct the government to treat covered children as eligible for purposes of federally funded welfare benefits. It asks us to stay the injunction insofar as it sweeps too broadly. We decline to take up these arguments in the first instance. The lower court should determine whether a narrower injunction is appropriate. We therefore leave it to them to consider these and any related arguments. 3. Respondents also defend universal injunctions as a matter of policy. They argue that a universal injunction is sometimes the only practical way to quickly protect groups from unlawful government action. Respondents also contend that universal injunctions are an appropriate remedy to preserve equal treatment among individuals when the executive branch adopts a facially unlawful policy. And they suggest that forcing plaintiffs to proceed on an individual basis can result in confusion or piecemeal litigation that imposes unnecessary costs on courts and others. So, they insist, universal injunctions must be permitted for the good of the system. The government advances policy arguments running the other way. Echoing Chief Judge Sutton, the government asserts that avoiding a patchwork enforcement system is a justification that lacks a limiting principle and would make nationwide injunctions the rule rather than the exception for challenges to many kinds of federal law. It stresses, as the principal dissent also observes, that universal injunctions incentivize forum shopping, since a successful challenge in one jurisdiction entails relief nationwide. In a similar vein, the government observes the universal injunctions operate asymmetrically. A plaintiff must win just one suit to secure sweeping relief. But to fend off such an injunction, the government must win everywhere. Moreover, the government contends the practice of universal injunctions means that highly consequential cases are often decided in a fast and furious process of rushed, high stakes, and low information decision making. When a district court issues a universal injunction, thereby halting the enforcement of federal policy, the government says that it has little recourse but to proceed to the Court of Appeals for an emergency stay. The loser in the Court of Appeals will then seek a stay from this court. This process forces courts to resolve significant and difficult questions of law on a highly expedited basis and without full briefing. The upshot, as with most disputes, there are arguments on both sides. But as with most questions of law, the policy pros and cons are beside the point. Under our well-established precedent, the equitable relief available in the federal courts is that traditionally accorded by courts of equity at the time of our founding. Nothing like a universal injunction was available at the founding, or for that matter, for more than a century thereafter. Thus, under the Judiciary Act, federal courts lack authority to issue them. Part C. The principal dissent focuses on conventional legal terrain like the Judiciary Act of 1789 and our cases on equity. Justice Jackson, however, chooses a startling line of attack that is tethered neither to these sources nor, frankly, to any doctrine whatsoever. Waving away attention to the limits on judicial power as a mind-numbingly technical query, she offers a vision of the judicial role that would make even the most ardent defender of judicial supremacy blush. In her telling, the fundamental role of courts is to order everyone, including the executive, to follow the law, full stop. And, she warns, if courts lack the power to require the executive to adhere to law universally, courts will leave a gash in the basic tenets of our founding charter that could turn out to be a mortal wound. Rhetoric aside, Justice Jackson's position is difficult to pin down. She might be arguing that universal injunctions are appropriate, even required, whenever the defendant is part of the executive branch. If so, her position goes far beyond the mainstream defense of universal injunctions. As best we can tell, though, her argument is more extreme still, because its logic does not depend on the entry of a universal injunction. Justice Jackson appears to believe that the reasoning behind any court order demands universal adherence, at least where the executive is concerned. In her law-declaring vision of the judicial function, a district court's opinion is not just persuasive, but has the legal force of a judgment. Once a single district court deems executive conduct unlawful, it has stated what the law requires, and the executive must conform to that view, ceasing its enforcement of the law against anyone, anywhere. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this: Justice Jackson decries an imperial executive while embracing an imperial judiciary. No one disputes that the executive has a duty to follow the law, but the judiciary does not have unbridled authority to enforce this obligation. In fact, sometimes the law prohibits the judiciary from doing so. Observing the limits on judicial authority, including, as relevant here, the boundaries of the Judiciary Act of 1789, is required by a judge's oath to follow the law. Justice Jackson skips over that part. Because analyzing the government statute involves more boring legalese, she seeks to answer a far more basic question of enormous practical significance. May a federal court in the United States of America order the executive to follow the law? In other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. Justice Jackson would do well to heed her own admonition. Everyone, from the president on down, is bound by law. That goes for judges too. Section 4. Finally, the government must show a likelihood that it will suffer irreparable harm absent a stay. When a federal court enters a universal injunction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against non-parties. That is enough to justify interim relief. The principal dissent disagrees, insisting that it strains credulity to treat the executive branch as irreparably harmed by these injunctions, even if they are overly broad. That is so, the principal dissent argues, because the executive order is unconstitutional. Thus, the executive branch has no right to enforce it against anyone. The principal dissent's analysis of the executive order is premature because the birthright citizenship issue is not before us. And because the birthright citizenship issue is not before us, we take no position on whether the dissent's analysis is right. The dissent is wrong to say, however, that a stay applicant cannot demonstrate irreparable harm from a threshold error without also showing that, at the end of the day, it will prevail on the underlying merits. That is not how the Enkin factors work. For instance, when we are asked to stay an execution on the grounds of a serious legal question, we ask whether the capital defendant is likely to prevail on the merits of the issue before us, not whether he is likely to prevail on the merits of the underlying suit. The same is true when an applicant seeks a stay in other contexts. So too here. The question before us is whether the government is likely to suffer irreparable harm from the district court's entry of injunctions that likely exceed the authority conferred by the Judiciary Act. The answer to that question is yes. And the balance of equities does not counsel against awarding the government interim relief. Partial stays will cause no harm to respondents because they will remain protected by the preliminary injunctions to the extent necessary and appropriate to afford them complete relief. Some say that the universal injunction gives the judiciary a powerful tool to check the executive branch. But federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power too. The government's application to partially stay the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. The lower courts shall move expeditiously to ensure that with respect to each plaintiff, the injunctions comport with this rule and otherwise comply with principles of equity. The injunctions are also stayed to the extent that they prohibit executive agencies from developing and issuing public guidance about the executive's plan to implement the executive order. Consistent with the Solicitor General's representation, Section 2 of the executive order shall not take effect until 30 days after the date of this opinion. It is so ordered.